Welcome back to Business Law Group class video. We are going to discuss today banker and customer relationship. Let's continue. Now, students, I'm going to split this particular class into class video into two parts. I'll be dealing with slide number 1 to 25 in my first video, and from 26 to 50 slides will be dealt with by me in my second video. So let us start. The topic: banker and customer relationship. Before we start discussion on relationship between the banker and the customer, let us see what is the definition of the customer. To constitute a customer, there must be some recognizable course or habit of dealing in the nature of the regular banking business. So the customer must be regularly dealing with the banking business. Then only that person can be called as customer of the bank. Suppose the customer doesn't have an account in a bank, he cannot be called as a customer of a bank. We have already seen that in our previous videos. Let us go ahead. Features of customer: he must have an account in a bank, he must deal with the bank, and his dealing must be in the nature of banking business and nothing else. And his dealing may be of short or long duration. He may have an account. So having an account is very, very essential to be called that person as a customer. At least he must have gone through so many transactions with the bank, whatever may be the duration. Say for example, if he maintains the account for a month and then after that he closes the bank account, yet he may be called as a customer of the bank because he had an account with the bank and he was dealing with the bank business. Let's go ahead. These are the relationship between customer and the banker. Let's see one by one. Debtor and creditor relationship, principal and agent relationship, fiduciary relationship, trustee and beneficiary relationship, bailor and bailee relationship, owner and pawnee relationship, mortgagor and mortgagee relationship, lessee and lessor relationship, guarantor and guarantee relationship. I will see one by one. These are the primary relationship, that is the debtor and creditor relationship. Now, if you can see in the picture, you will see two people looking at each other. The first person is the debtor who has taken loan from this particular person, and he is the creditor. He is called as a creditor. Debtor is the person who has taken the loan from him. Now look at the attitude of this particular person. He has advanced money to him, and look at the reaction, or look at the face of the person who has taken the money. He feels guilty. He feels obligations to pay back his money, and he is seen as demanding the money. Say, I have advanced you the money and you need to pay me back. This is the relationship. This kind of relationship is there between the banker and the customer. Okay. What are the essential features of debtor and creditor relationship between the banker and the customer? Demand for money. So demand for money can be done both the ways. For example, if I have deposited my money into my savings accounts in a bank, I have every right to demand that money at any time I want. Then demand must be at proper time. Proper time in the sense within the working hours. Demand must be in proper manner. I cannot just go on the counter and say that whatever money is deposited by me, just pay me back. No, you need to fill the withdrawal slip, or you need to bring the check and then present it at the cash counter, and then your money will be paid back to you. Okay, so this is called as debtor and creditor's relationship. There are certain case laws from which we can understand this relationship. Try to understand this relationship. Foley versus Hill. The relations of a banker and the customer is primarily of the debtor and the creditor. That is the decision of that particular case. Jorgensen versus Swiss Banking Corporation. It was held that an express demand by a customer in writing is essential to get back the deposited money. Orally, you cannot demand money from the bank. Next, Clare and Company versus Disdain Bank. It was held that locality is an essential element in a bank. banking debt, and the banker should pay it only when the demand is made at the branch where the account is kept. Suppose you are asking for money from a from your branch, okay? It has to be honored only if you ask at the right branch in which your account is there. Next, Arab Bank versus Barclays Bank. A banker is liable to honor a check provided it is presented during banking hours. Let us see the next relationship, principal and the agent relationship. There are certain two cases from which you can try to understand this relationship. First is the Bank of India versus official liquidator. Bank acted as an agent for collection of the checks. So whenever the checks are presented to the bank for honoring or encashment, the banker acts as an agent of the account holder. Next, Bharat Bank Limited versus Kashyap Industries. The bank was liable to pay compensation to the plaintiff for the loss caused due to the negligence in presenting the invoice to the third party. Now, the bank was at default, so because of that, it has to pay. It had to pay the compensation for the loss caused to the customer. Next, fiduciary relationship. Fiduciary relationship between the banker and the customer results when the money is paid to a bank with the special instructions or to retain the same pending further instructions. Now, I deposit money in the bank and give instructions not to deal with that particular money unless and until I instruct you to do certain things. So this is called as fiduciary relationship between the customer and the bank. Now there was one case, official assignee of Madras versus Rajaram Iyer. When the bank holds money for a specific purpose of sending it to somebody, the money is impressed with trust. That means what? Suppose I, I request the bank to hold that particular money and send it to someone on my behalf. So banker cannot refuse it. The banker has to honor them. That relationship is called as fiduciary relationship. Next, we have trustee and beneficiary relationship. There was one case, New Bank of India Limited versus Parle Lal. When money is paid to the bank to pay the same to other person who has no account, and the bank accepts the instructions and holds the money, a trust results and the bank continues to hold the money as a trustee. So there is a bank can also act as a trustee of my money because I deposit that money with trust. I trust the bank. The bank can hold my money as a trustee. Next, bailor and bailee relationship. When banker receives gold ornaments and important documents for safe custody, the banker takes charge of goods, articles, etc. as bailee and not as a trustee or agent. In this case, he cannot make use of them to its best advantage because it is bound to return the articles on demand. Now, this is an example of a locker in the bank where we can keep our valuables in the lockers so that they remain safe from being robbed. Now, the banker holds those articles as a, a bailee and not as a trustee or agent. That means what? The banker cannot make use of those articles for its own benefit because it has to be kept in a locker, and uh, if I demand as a customer, I have to be returned those articles immediately after my demand. So therefore, there is a relationship between the bailer and the bail. Pawner and Pawnee relationship. Pawnee is a person with whom a pledge or mortgage of payment of money lent is deposited. Pawner is a person depositing the pawn. Pawn is the thing given, deposited, or left in another's keeping as a security for debt or for performance of some action. Now, anything which is kept with the bank for further action, it is called as pawner and pawnee relationship. Mortgager and mortgagee relationship. Mortgage is transfer of an interest in a specific immovable property for the purpose of securing the payment of money, advance, or to be advanced by way of a loan. Case Punjab National Bank Limited versus Diwan Chand and others. In this case, the bank was held liable to compensate the mortgagor for the loss suffered as the mortgagee had failed to carry out failed to carry out the instructions of the mortgagor in connection with the renewal of insurance of the mortgage property. Okay, so there was a insurance which was supposed to be renewed. It was not renewed, and the bank had to pay compensation to the customer. So mortgager and mortgagee relationship. Next, lessee and lessor relationship. When a customer hires a locker in the banker's safe deposit vault, the bank undertakes to take necessary precautions for the safety of the articles left in the locker. The relationship between the parties is that of the lessor and the lessee. Then guarantor and guarantee relationship. Bank guarantee. Guarantee is one who gives a promise to answer for the payment of some debt or the performance of some duty in the case of the failure of another person. Next, special features of relationship. Now there is a relationship in the sense there are certain rights and duties towards each other. Bankers' rights are duties of the customer, and bankers' duties are the duties or rights of the customer. These rights and duties are called as special features of relationship between the banker and the customer. Special features: general obligation of a banker towards customer to honor the check, to maintain secrecy and disclosure of information required by law. The rights of the bankers are right to lien, right to set off, right to for appropriation of payment. General obligations. Further discussed. Honoring of check is if defaulted liable to pay compensation. So if the banker fails to honor the check, in spite of the fact that I have sufficient balance in my bank, the whatever loss is caused to me, the banker has to pay me back the compensation. And there is one case, Fleming versus Bank of New Zealand. Banker's duty is to pay checks of current account holder. Banker will not injure his customers' credit by refusing to pay checks. Next, conditions for honoring checks. Now, whenever a check is deposited in the bank, it has to be honored by the bank. Now there are, but it cannot just honor the bank check unless and until these conditions have to be satisfied. The first condition is sufficient balance. There must be a sufficient balance of the customer in the bank. Then the check must be presented within working hours. The check must be presented within reasonable time. Reasonable time in the sense within validity and within the time which is fixed by the bank for the acceptance of the check for payment. Then presentation at the branch where account is kept. Now this is very important. It has to be encashed from the bank where the account is there. Then signature of the customer is very important, and it should be matching with the records of the bank. Then proper form of check. The check must be in the proper form, the latest one, which is issued to the customer. Mutilated checks. Now any check which is torn or which has been made dirty by the customer, the person who is presenting the check, if it is mutilated beyond recognition, then it will not be accepted by the bank. Next, correctness of amounts in words and figures. Whatever amounts are written in the figures must reflect the same amount in the written in words. So if they are not matching, the bank will not accept. Next, material alteration. Now, whatever alteration is made on the check, if it is not authorized alteration, the bank will have a doubt on the veracity or the genuineness of the check, and then it will not honor. Next is proper application of the funds. So whatever funds are already available in the bank, it has to be properly appropriated. Then reasonable time for collection. Reasonable time for collection in the sense. Now let me explain this proper application of funds. Now in certain cases where there was a condition where Prime Minister of India announced demonetization. At that time, the bankers had limitations of paying back or honoring a particular check. So banker will have to honor a check depending upon whatever instructions were received by from RBI to honor a check to how much amount. Okay, so that's the proper application of fund. Next, a reasonable time for collection. So the collection must be done within a reasonable time. Then existence of legal bar. Now, for example, if the court has frozen the account of the customer and it has given an instruction to the banker not to honor any kind of check of that particular person, the banker will refuse to honor the check. Next, death, insolvency, etc. of the customer. If a person has brought a check which has been issued by the person who has already expired, that means it must be uh, taken by fraud. Okay, so he has collected the check by fraud, and then he is trying to present it in the bank after the death of the actual uh, uh, account holder. So it will not honor the check because the person has died. Next, checks of partnership firm company account. So checks of partnership firm company account needs signatures by both the parties, or whatever acting parties partner. So if it is not applied properly in a proper manner, the banker will refuse to pay the check. Next, obligation to maintain secrecy of accounts. Now, there are legal necessity. It will disclose if it is required. For example, these are the acts under which the banker is obliged to disclose the information of a customer. Otherwise, you cannot collect any information without a proper call. I cannot just go into the bank and ask about the details of my friend's account there. He will say, "Where is your friend?" The banker will ask for the permission, whether that the friend has given you permission to collect the information from us. They are not going to disclose any information to a third person. But under these circumstances or under these acts, if it is provided in the particular act that disclosure is required to be done, or if it is ordered by the court that the banker has to uh, provide information to the authorities for certain kind of investigation or whatever. So, as far as income tax is concerned, the banker has to disclose the information. Companies Act, now it has been amended, and we have Companies Act 2013. RBI Act, if RBI Act wants the information to be disclosed. Bankers Books Evidence Act in case of criminal investigation. Banking Regulation Act in case of fraud. Gift Tax Act, Criminal Procedure Code in case of again criminal activities. Garnishing order to court. That means if the banker has, the court has instructed banker not to honor the checks. Next is Foreign Exchange Management Act, Regulation Act. If this act demands information disclosure, the banker has to do it. But only thing is the court has to order it. Next, what is garnishing order? Garnishing order is nothing but the obligation of a banker to honor his customer's check is extinguished on receipt of an order from the court known as the garnishing order. If a debtor fails to pay the debt due to his creditor, the creditor may apply to the debtor bank to issue this order, or court to issue the order to the bank so that the bank account is frozen. So the garnishing order is divided into two parts, ordinacy and order absolute. Ordinacy means directs the bank to freeze the debtor's account or seeks the banker to explain why the funds in account should not be used for payment to the creditors. That means the account is frozen and no other checks will be honored. Next is order absolute, directs the banker to pay either the whole or part of the funds lying in the account. Banking practice, disclosure with customer consent. Now, certain disclosure may be made in case the customer expressly says so. So, express consent, that means customer can instruct the banker to disclose the information. And implied consent means the guarantor who takes the responsibility of the debtor. Disclosure for banker's own interest to banker's lawyer, recovery of dues. Now, for example, otherwise it is not required. But suppose a person who has taken a loan fails to pay back, then the banker can disclose the information of that particular person's accounts to the lawyer, so that for the purpose of recovery of the dues and for further process. Disclosure of request by other bank can furnish data except the actual figures. So if other banks have asked for the information, then it can furnish information to that other bank if it is required. Disclosure for public interest when it helps to find a criminal or person involved in illegal activities. The disclosure has to be done to the investigating authorities. Now, I'll give an example of this disclosure of request by other banks. See, I had transferred 1,000 rupees to my brother. Now, while transferring by way of online transaction, NEFT, from my own mobile phone through my UCO Bank app, while transferring the money, I made a mistake. I typed one wrong digit, and the money went to the some other's account. Now, how to get this particular 1,000 back? So I made an inquiry at Bank of India from that particular place where I had transferred, in which my brother's account was there, and then I had inquired in my UCO Bank also. So they told me that I need to furnish the account details of the person to whom I have sent or credited wrongly, and the information of the account holder actually I am supposed to send. Okay, so only there was a difference of only one digit. So because of that, I had to email to the Bank of India at that particular place, and then that Bank of India had informed the UCO Bank. Again, I had to inform the UCO Bank by email. And so there was a coordination between those two banks. They found out, I gave all the details, and then they found out, they took the information from each other, and then recently I got that 1,000 back in my savings accounts at UCO Bank. So that bank has reverted that payment back to me. So this is disclosure of details of customer on the request. Okay. So as I was dealing with, this is the latest case which is going on. CBI is inquiring the bank accounts of Riya Chakravarti as to find out how she got so much of money deposited in her bank and all these things. Now this is the disclosure of information for the purpose of investigation to find out the criminal who has done wrong. Now, students, this is the end of the first part of my lecture. I will stop here and I will continue with the topic relationship between the banker and the customer in my next video. Thank you so much.